We all love a good David versus Goliath story, right? Well, today we have a fantastic one for you. But forget slingshots. This battle was fought in the super high-stakes world of pharmaceuticals and patent law. It's the story of how a small local company took on an absolute global giant and, believe it or not, actually won.
So the big question is, how did this even happen? I mean, how does a small firm manage to outmaneuver a pharmaceutical titan like Pfizer? It wasn't about having deeper pockets or a bigger army of lawyers. No, the answer really comes down to a ticking clock and one single critical mistake that unraveled their entire billion-dollar case.
All right, first things first, let's set the stage. At the very heart of this huge conflict is a massively valuable asset, the patent for a blockbuster antibiotic. So on one side, you've got Pfizer, the global pharmaceutical titan we all know. And on the other, Phil Pharmawealth, a local company in the Philippines. And what's the prize they're fighting over? It's the patent for something called sulbactam ampicillin, which Pfizer markets under the super successful brand name Unison.
Now, before we dive any deeper, let's just do a real quick refresher on what a patent is. You can think of it as a government-granted monopoly for limited time. For a company like Pfizer, a patent on the drug like Unison is basically a golden ticket. It's the exclusive right to make, use, and sell that drug, which protects billions, yes, billions of dollars in revenue.
So you can imagine, when Pfizer found out that Phil Pharmawealth was bidding to supply this exact drug to hospitals, they launched an immediate and aggressive legal attack. We can call it a full court press.
Okay, so here's how Pfizer's attack unfolded. First, they sue Phil Pharmawealth at the Intellectual Property Office, or the IPO. And at first, it works. They score an early win and get a 90-day injunction. But then, the IPO refuses to extend it. So what does Pfizer do? They make a really bold move. They file a second, almost identical lawsuit, but in a totally different court. And that decision? Well, it was going to come back to haunt them. This quote right here from Pfizer's actual complaint really gets to the core of their argument. They're basically saying, hey, Phil Pharmawealth is bidding on our turf, violating our intellectual property rights. So from their point of view, they were just protecting what was legally theirs. Totally understandable, right?
But here's the thing. While all these legal battles were raging, there was a clock ticking down in the background, counting down to one simple, unchangeable fact, a fact that would ultimately decide the entire case.
Let's just walk through this timeline. The patent was issued way back in 1987. The whole legal fight kicks off in 2003. But look at that very last date, July 16, 2004. On that specific day, 17 years after it was first issued, Pfizer's patent was set to expire. And the second that patent expired, the number of exclusive rights Pfizer had to this drug formulation dropped to exactly this: 0. Nothing. Nada.
And this is the absolute crucial point. The legal monopoly that Pfizer was fighting tooth and nail to protect, it just vanished into thin air. After that date, anyone, and I mean anyone, including Phil Pharmawealth, was legally free to make and sell sulbactam ampicillin. The entire game had just completely changed. So, as you might guess, this legal battle eventually went all the way up to the Supreme Court. The justices there cut through all the noise and just boiled this whole complex mess down to 3 fundamental questions.
First up, the most obvious question, really. Can you legally stop someone from infringing on a patent that doesn't even exist anymore?
And the court's answer was a huge, resounding no. See, an injunction is meant to protect a right you currently have. The second Pfizer's patent expired, their exclusive right was gone. Poof. You just can't protect a right that no longer exists. Simple as that.
The second question was, a bit more of a legal technicality. It was all about jurisdiction. Basically, did Pfizer appeal to the right court when the IPO first ruled against them? And you know what? On this point, the court actually sided with Pfizer. The law was a little fuzzy, so Pfizer's decision to go to the Court of Appeals was the right call. So they won this little battle. But the war? Well, that was about to be decided by the third and final question.
And here it is, the big one. Remember how Pfizer filed that second lawsuit after the first one hit a roadblock? The court had to decide if this was something called forum shopping.
So what in the world is forum shopping? Well, it's pretty much just trying to get a second bite at the apple. Think of it like this. You ask your mom for permission to do something. She says no, so you immediately run to your dad and ask the exact same thing, hoping he'll say yes. The legal system has rules against this because it clogs up the courts and can create just a ton of conflicting decisions.
And the evidence against Pfizer here? It was pretty damning.
When the court put the two lawsuits side by side, the demands were basically identical. I mean, look at this. In both cases, Pfizer wanted to stop Phil Pharmawealth, grab their sales documents, and get a permanent injunction. It's a carbon copy.
So the court's answer was an emphatic yes. They said, look, even though you use slightly different words, the objective was exactly the same. The court called it willful and deliberate forum shopping. And that right there, that was the fatal blow to Pfizer's entire case.
So what's the big lesson we can take away from all this? It's a really powerful one, actually. In the legal world, a smarter strategy can often beat brute strength, plain and simple. So let's recap the key takeaways here. First, patents have a hard deadline, period. Second, trying to game the system by filing the same case in different courts, that's forum shopping, and it's a huge no-no. Ultimately, this case just proves that winning isn't just about having the biggest legal muscle. Phil Pharmawealth won because they understood the rules, while Pfizer, in its aggressive push, broke them.
You know, this case leaves us with a really critical question. Pfizer was trying to protect a valuable invention, which is the whole point of the patent system, right? But was their full court press a legitimate defense, or was it just an attempt to use their immense legal power to crush a smaller competitor even after their patent rights were gone? It really highlights that fine line between protecting innovation and unfairly stifling competition. What do you think?